morning, everyone, and welcome to today's webinar titled Turning the Tide, Analyzing the ICJ AO Judgment and its Implications for Climate Justice in Africa. My name is Nomasango Masiamoyo, and I have the distinguished pleasure of welcoming you all to today's session, as well as moderating it on behalf of the Environmental Lawyers Collective for Africa and Natural Justice. Now, in July of this year, the International Court of Justice delivered its advisory opinion on states' obligations in respect of climate change. This was a landmark moment for global environmental law and justice. For many in the climate and environmental justice community, this opinion is progressive, setting out clear expectations for states' duties under international law. Yet, voices, particularly from the extractive sector, have criticized it as ambiguous, especially in determining who bears the greatest responsibility for what and in which periods of time. This tension provides a really intriguing and important backdrop for today's discussion. We're really here to explore what the advisory opinion means for Africa, its potential for advancing climate justice, and the opportunities that it presents, as well as the challenges that it poses. But before we dive in, I'm just going to go through a couple of housekeeping issues. The webinar today is scheduled for 1 hour, 30 minutes. You're going to hear from 4 distinguished speakers who will each take about 15 minutes to unpack very different perspectives and aspects of the advisory opinion process, as well as its relevance for the continent. After the presentations, we're going to move into a Q&A session where hopefully we're going to hear some thoughts from all of you about some of what our speakers have said or some of the engagements that you've been making in the chat box. We really apologize. Today there is no French interpretation, but we would like you to look out for a recording of this webinar that's going to be made available and going to be dubbed in French. This is going to be an interactive session, so I will encourage you to engage with some of the questions that I'm going to drop in the chat box for you as we're listening to some of the speakers making their presentations. So let's begin with our first speaker. Our first speaker is called Joy Chowdhury. Joy is a senior attorney in the Climate and Energy Program at the Center for International Environmental Law. Before joining the center, she worked at the International Network for Economic, Social, and Cultural Rights, as well as at several other organizations and academic institutions. Joy has taught courses on international human rights law, comparative constitutional law, and climate justice. She co-leads a coalition of civil society organizations that have been involved in the ICJ process and speaks to us today regarding the importance of civil society action in directly shaping the court's pronouncements. Please welcome Joy.
Thank you so much, Noma. It's an honor to be here today. And yes, as Noma mentioned, the ICJ's advisory opinion was a historic legal breakthrough. It marks a watershed moment in international climate law, delivering unprecedented legal clarity on states' obligations in relation to climate change, and adopted unanimously by all 15 judges of the world's highest court, drawing on binding international norms, and its authority is undeniable. As Noma mentioned, the court delivered a clear roadmap to hold polluters accountable under multiple sources of international law, extending beyond the climate treaties, and to secure the right to remedy and reparation. So today, what I'm going to do is speak a little bit about the role of civil society in creating powerful movement infrastructure around the case and how this actually impacted the outcome that we have today. I will share a PowerPoint presentation and we'll get started after that. Hold on. Let me see. Can you see the presentation?
Yes, we can see it now.
Wonderful. All right. So before I start, just a disclaimer that this is obviously very based on the ICJ specific modalities and how this will translate, because now all eyes are on the African opinion process and the proceedings that will happen around the petition that was submitted to the African Court on Human and People's Rights. So it may not look exactly the same how these modalities work because the ICJ has some very specific procedural aspects that tend to make it a bit more closed to civil society participation, and yet civil society really led in many ways in the proceedings. So that is what we'll discuss today. I'm just going to make sure that I stay within the time allotted. Let me just make sure that I have that on. Okay. So let me take you back to how it started, back to the beginning. So this started as a campaign. The idea of the ICJ advisory opinion about taking the world's biggest problem, climate change, to the world's highest court, the International Court of Justice, this was born in a classroom. It began in 2019. It was a class assignment which was completed by 27 law students at the University of South Pacific, where they came up with this idea of really really asking the International Court of Justice to provide clarity on what are the international legal obligations of states in relation to climate change because of their concern about intensifying impacts of the climate crisis on human rights of people and the inability of existing systems to address these threats. And the campaign to take the world's biggest problem, as I mentioned, was born in the classroom, but then was taken up by Pacific states first and by then a broad coalition of states around the world. It was backed by a global youth movement and a powerful coalition of civil society organizations from all regions of the world. And with this global support, this was the UN General Assembly unanimously requested the ICJ opinion. There was no objection from states in sending the request to the court to clarify states' duties in relation to climate change. And what happened, what was dreamt up, what was sparked in a classroom, essentially led to the world's biggest climate case. 100+ countries and organizations participated in the hearings and written submissions and throughout the proceedings. So we got an unprecedented glimpse of the positions of different countries on different legal aspects. And now with the African AO proceedings coming up, we really hope and expect these regional aspects to be deepened and sharpened in due course. So to talk a little bit about what the civil society coalition space looked like. So we had the broad, around the case, we had the broad AO Alliance. This was led by the Pacific Island students fighting climate change, but had a wide range of organizations, and this still persists. We continue to work together today. And we also in this space had friendly states who would come in and share top line points about their strategy and where civil society could support. And there was a kind of loose level of coordination. And of course, the approach states take can be very different from sometimes how civil society decides to take issues forward. But there was that space for conversation. So the AO Alliance was this civil society collaboration space, and it started, back in 2019 and has been the kind of heart of the ICJAO proceedings and now the implementation efforts going forward. Then we had another space that came up around the legal work that organizations were doing around submissions by civil society in the ICJAO proceedings. This kind of loosely came together from partners who are specifically working on the very legal aspects of the proceedings. And this was the space that Noma mentioned that I co-lead, and we work in very deep alliance, very deep collaboration with the AO Alliance. And essentially that coordination and collaboration was very key in being able to be very effective in the work that we were doing around the case. And then as the campaign started heating up, especially during the orals, which was a very pivotal moment for the proceedings, There was a separate coordination space that came up, which is called the Hague Mobilization Task Force, which specifically focused on the coordination and collaboration around direct actions, around the campaign elements. And that can be very different, the conversations that we would have in different spaces. What was essential was that there was clarity in roles on which topics were kind of led on by the different spaces, and that there was an open channel of coordination and communication happening between the different spaces. So we were together a powerful force working around the case and working to advance key climate justice demands within these modalities and the spaces that the ICJ-AO proceedings allowed for. One other aspect to note, even though this may not apply in other court proceedings, is that the ICJ has very confidential aspects to some of the phases of the proceedings. For example, the written submissions that states made were not made publicly available to the public were not made available to the public till the start of the oral hearings, which obviously then makes it difficult and challenging to effectively coordinate and plan around the case. So there are those aspects, which meant some of that information was getting shared, but on a very confidential basis, which meant the civil society coalition spaces had to have that level of trust and confidentiality as well, something to keep in mind. And what was also really important was that we had partners from all over the world, which for the ICJ, because of its broad jurisdiction, really helped in able to coordinate effectively at a regional level, at a national level, to be able to reach national governments with civil society demands. So that was a really important aspect as well. So what did we do as civil society? We did legal submissions, so we worked together amongst these different spaces. The ICJ-AO proceedings is, as I mentioned, the ICJ generally is a bit closed off to civil society participation, but there is, in the advisory proceeding context, the ability to submit legal submissions under Practice Directive 12. And so we worked together to have a very strong set of submissions that were made by civil society and that I know for a fact was consulted by states. Because of the way the ICJ worked, there wasn't a lot of understanding that we had from our end how this was being considered, and it was not made public, for example, on the court's website. But we spoke with the judges at a public event at one point, and they mentioned how they had asked the registrar for the legal submissions. The judge who we were speaking with, said she could not speak for all of the different judges of the court, but that a number of them do take Practice 12 directives very seriously and had consulted them. And indeed, when you look at the outcome, this is very evident that they looked. The way civil society can shape arguments in a case can look different from the way states shape arguments, and I think made a profound difference in the transformative outcome that we saw. We also had direct interventions that were made before the court by the youth leaders of the civil society space. So you had Cynthia, who's pictured in the slide. She's the president of the Pacific Island Students Fighting Climate Change. And in the joint opening intervention of the public hearings of the case, Cynthia was part of the delegation of Vanuatu and the Melanesian Spearhead Group, and her intervention was one of the most powerful of the entire public hearings. Similarly, Vishal, who leads the Pacific Island Students Fighting Climate Change, and is their director, also made a direct oral intervention before the court, which was very powerful. And you also had Brenda and Mert from the World's Youth for Climate Justice being part of different state delegations and intervening before the court. It was the first time you had youth interventions before the court, and it was a very clear call for a climate justice approach to the questions before the court. One of the things many of us worked on as part of those civil society coalitions was calling for fairer procedural rules. And this was not something we did very publicly, but we did behind scenes, because for many states, it is not easy in a way to engage in these proceedings. Something as simple as taking a flight from their country to The Hague can be extremely resource intensive. You might have two people within a state who handle their entire international law docket, so which means the deadlines also need to take that into account. So there were a number of different procedural issues that states raised with us, and they brought up directly with the registrar's office, but we also provided support behind the scenes with the calls for a fair procedure. There was diplomatic engagement that happened with partners rooted in different national contexts, rooted in different regional contexts, who really engaged with the international organizations and states that were participating in the proceedings to call for very specific climate justice focused arguments, to ask them to include those arguments in their submissions. And we saw, for example, a few of the issues that we consistently asked states to include, that we supported states with direct language, did make it into submissions and was reflected in the final outcome. It's also interesting to see how those diplomatic networks and connections work out, in the sense many of our diplomatic contacts came from other types of multilateral spaces, but because we had those close connections with states, we were able to then ask them to connect us with the relevant contacts within the government who are working on the case, to be able to then present those calls that we made. So that worked out. Another thing that we did was closed door cross-regional state briefings, bringing together experts and really providing a safe space to discuss the very technical elements of different arguments. There was also a very powerful campaign mobilization element, direct actions, demonstrations, mobilization sessions. There was a beautiful initiative by the Pacific Island Students Fighting Climate Change and others within the coalitions, called the witness stand, because, as I mentioned, the court can be a bit closed off in terms of direct civil society participation. The witness stand was a beautiful way to collect very moving testimony from people who are the most affected by climate change from different countries all across the world and starting in the Pacific. And this was really powerful. And then it was mentioned directly in the formal proceedings, so that external mobilization effort was then brought into formal record. There were ways of bringing and breaking down and demystifying for the broader public about what was happening, because sometimes law can become very much about jargon, but we know that the issues that we are bringing before the court are not abstract technical issues. These are actual violations taking place in the here and now that deeply affect our communities and our peoples. So the ability to break down the process is really important for something like an advisory opinion to actually matter for the day-to-day work of climate justice movements. And then there was a big push to shape the narrative. We actually worked very closely with strategic communications colleagues to make sure that civil society's narrative, the narrative of the front line, was the narrative that was leading on the case, rather than, the narrative of the extractive industry. And make no mistake, they put a very big push, and they have a very strong strategic kind of tactics that they bring to all of this in terms of shaping the narrative. So it is really important from the very start to be thinking about, how do we work in different fora? How do we use events? How do we use traditional media, social media, to shape the narrative and to really get the word out there in terms of what a process like this could mean in terms of actual change? And then, to wrap this up slowly, and to conclude, the importance of civil society's role. There was immense power in youth leadership. It is profoundly important that this historic legal proceedings that led to this transformative outcome from the ICJ was initiated by Pacific youths, and that was then backed by the strong campaign of global youth and other organizations from all across the world. Especially youth leadership really mattered. We saw Pacific youth and youth campaigners, in particular the Pacific Island students fighting climate change and the world's youth for climate justice, reframing climate change not just as a science and technical issue, but as a justice crisis, linking human rights, intergenerational equity, and state responsibility in a way that deeply shaped the legal arguments and global momentum. This was not elite diplomacy or black letter legal arguments alone. It was grassroots lawmaking led by the clear vision of frontline youth lawyers and campaigners, and rooted in deep love for communities, territories, and the ocean, and a refusal to accept an incremental approach. And through storytelling, through powerful mobilizations, through coalition building across people's movements and civil societies, through engaging with states and on their arguments and directly intervening before the court as part of state delegations, youth leaders infused every aspect of the proceedings with a climate justice perspective and definitively reimagined whose perspective defined international legal discourse. And because of this origin, the advisory opinion carries unmatched legitimacy and moral force. So I'm going to end here. I'm happy, of course, to answer any questions. And wonderful, I see Justin is online and will have very useful and rich insights to share. So back over to you, Luma.
Thank you so much, Joy. I think you've helped to anchor today's discussion, giving us that contextual background about just how important civil society, as well as the youth, were at initiating this AO process, but not only just initiating, driving the process as it was going on, and how these ideas that were incubated in the classrooms that you referenced then moved into real diplomatic strategies anchored in trust, strategies anchored in disciplined messaging, and in friendly state engagement, it sounds like. And I think it helps us to better understand how you were able to open the court's door, but also why there may be some discomfort with the fact that whilst there's some obligations that were highlighted by the court as being broad obligations, and there's a lot of rights-based framing in the judgment, there is still some cautious language when it comes to allocation and accountability mechanics. And I'm hoping that Justin is going to be able to flesh that out for us a little bit and unpack what the court actually said and where it tracked this civil society framing when it came to prevention, when it came to precaution and fossil fuel duties, and where it fell short on who owes what and when. So I'm going to, before I introduce you, Justin, I'm gonna say a little bit about you. Dr. Justin Soybion holds an LLM in international law from the University of Cape Town, South Africa, and an LLM and PhD in environmental law from the University of Auckland, New Zealand. So he is triple degreed. Or quadruple. In December 2024, Justin acted as counsel for Grenada and St. Vincent at the International Court of Justice's advisory opinion process. He was also the coordinator for Caribbean states during the ICJ process. He talks to us today very briefly about some salient findings from the court's judgment, as well as their global relevance. So please welcome to the global stage, Justin.
Thank you. Thank you very much, Noma, and greetings to all. Thank you for inviting me to this webinar, and I'm very honored to follow my good friend Joey as well in Geneva. And I'm actually joining because I'm based in New Zealand. So I actually got home a little bit late from work, so that caused me to be a little bit late to the webinar, but at least I made it just in time. And it's nighttime now, and I'm of course happy to be here just to share some of my thoughts. Uh, so yeah, I did represent, well, I was a co-counsel for Grenada and St. Vincent and the Grenadines, two small island states in the Caribbean. And I also acted throughout the process from the very start because of my location in the Pacific region. I was able to at the start be advising the Pacific Island students with a gentleman called Solomon Yao, who was the main protagonist of these whole proceedings. The former leader, the first leader from the Pacific Island students, Solomon Yao from Solomon Islands. Actually, Solomon was here in New Zealand promoting the story as well in the Pacific Studies Center in the University of Auckland. Uh, so Solomon and I had a good get go, good meetings from the start, and when he found out I was from the Caribbean region, he wanted um, me to assist and advise in getting Caribbean countries on board. So on that part, I started off as the Caribbean coordinator unofficially, and then it ended up being a more official role. So what I just want to share as Noma, I mean, I spoke to Noma before, but just wanted to share what I thought were some of the key findings of the ICJ advisory opinion. And uh, to be quite honest, I think most of us in the room, if you had asked me before what the ICJ would have produced, I was cautiously optimistic. Um, but I did know that we have 15 judges, well, 14 because the former president stepped down to become prime minister of Lebanon. But nevertheless, we have 14, 15 judges who heard the case originally, um, from all different backgrounds, legal cultures, from the United States, Australia, Japan, Germany, France, South Africa. Uh, and we weren't quite sure how the judges would be or would react. In fact, the ICJ is known as a a very conservative judicial arm of the United Nations. But I must say, I was pleasantly surprised, and I think most of us were surprised by the breadth and depth that the ICJ got into. The first thing I would want to touch on is they confirmed, just like it lost before, that was not really the biggest surprise, but that IPCC science is the best available science, and they heavily relied on IPCC science. That wasn't a surprise, but it just gives the panel of IPCC scientists more weight, especially as we go into the next COP in Brazil. The second point I think that they raised was that climate change is not only uh, lex specialis environmental law issue. So we're not only going to focus on the Paris Agreement, the Kyoto Protocol, or even the UNF Triple C. Uh, they said that the lex specialis argument, which many of the global north countries relied on, basically went through the window, and we were a bit concerned about that argument, even though it lost, of course, rejected the lex specialis arguments, and the same arguments were rehashed. So they said we could also rely on the core human rights treaties, which of course is the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, and other customary international laws, and certain environmental laws, treaties. I think they named about 8 as well. So climate change is really not only an environmental issue, but a human rights issue. And I think that is extremely important, especially that confirmation, especially coming into now the advisory opinion we are going to see possibly next year in the continent in Africa, where climate change is specifically a human rights issue. You're talking about droughts, you're talking about you know different issues related to human rights, lack of water, all these things all bundle up together. So I think in terms of that respect, I think that is important for the upcoming advisory opinion. The next thing I thought was very critical was the right for future generations. Again, the ICJ did speak about future. They said intergenerational equity forms a corpus of the body of international environmental law. This was said by Justice Trinidad um, Cansado, the deceased judge from Brazil, in a past case. So, but and Judge Weraman III, former vice president from Sri Lanka, he also spoke about that about the intergenerational equity. So we knew the foundation was there, but we needed to build on it. And the ICJ did accept intergenerational equity because what is future persons? What is the rights of the future generations? In law, well, generally speaking, some persons might say the future generations are your your 2 year old son, your 1 year old daughter. But in law, technically, that is not realistically, that is not future generations. Future generations is someone who is unborn. So future generations would be someone who would be born in 2030, for example. So some states like Germany and I think Saudi Arabia, just some that I remember, said that, well, why should we as states have the right to protect someone who is not even born yet? Human rights is just what it is. Human rights is the rights of a human being. But of course, we looked at it from the environmental context that the future generations have not consented to the climate crisis. And then the future generations are going to be unduly burdened by the climate crisis. So, with that respect, the states have to have the future generations in mind. And in that, if you look at paragraph 156, and I quote here, the court says intergenerational equity as is the expression of the idea that present generations are trustees of humanity, taken with tasked with presenting dignified living conditions and transmitting them to future generations, and that the effects of global warming will cut across generations. So, with that respect, that was a victory for us in Grenada, St. Vincent and the Grenadines, and all the Pacific Islands and other states that said that the court should take into consideration future generations and that the present generations are trustees. That is the type of terminology that we advocated for. So, we're happy that that was there. Um, Noma did touch on the next issue with fossil fuels. Again, this to me, this was one of the um, most surprise judgmental ruling for me that came out. I remember sitting down next to Bahamas and St. Lucia. And when the judges talked about fossil fuel subsidies, I was in the middle, and both of them were like hitting me and elbowing me, and like, look, you see, and look, they talk about that, and I was like, let me hear what they said. I need to hear it properly, And but they said fossil fuel subsidies, fossil fuel consumption, fossil fuel licensing, reliance on states on these activities, they said may, okay, the ICJ, of course, being conservative, but may amount to an international wrongful act. And I think the continuation of that, we could actually use that particular paragraph. Let's go back 2 years, 2 years ago. I believe it was in it was in the COP Glasgow, I believe. I didn't attend, but I remember that they said that um, if you recall, India and China changed the text to saying that we should not only phase out fossil fuels, we should phase down, and that was a big debate. But now, with this, you can say there's no room or scope for phasing down. You need to phase out because the ICJ has said that what you do, fossil fuel consumption, fossil fuel licensing, subsidies, etc., that if you continue to do these acts, knowing very well that the IPCC is the best available science and they have spoken out against it, your state may be able to attract international liability or may be internationally performing a wrongful act. So I think that is a very critical part of the judgment. Um, there are many things I would like to touch upon as well. Let me just at least talk about briefly about two more: sea level rise. The ICJ also said, if you recall, under the Montevideo Convention, one of the criteria for being a state is that you must have a territory, you must have a population, you must have also a government, etc. but the Montevideo Convention specifically says that you must have a territory. And us as small island states, and bearing in mind that Africa is a continent, yes, but Africa also has small island states. There's Seychelles, there's Mauritius, there's Madagascar, which is, of course, a much, there's Comoros. Madagascar is a bigger, almost like a continent in itself, but still it's an island. Um, uh, th- they said that states that are underwater basically or losing land based on sea level rise, states are not under obligation to renegotiate their maritime boundaries. And I think that's they're signaling there is that the land is still there. It's just underwater because of climate change. So the territory really exists. That's my interpretation of it. So I think for small island developing states and small island states in Africa as well, that is a important thing to look at. There may be some challenges on how we actually interpret that ruling in the future going forward. Does that mean that if you're totally underwater, you could still be a state? It does give food for thought as the process of where the ICJ is going and how we would like to actually move forward in terms of international maritime boundaries. And last but not least, I think I wanted to refer to climate change and its effect. Well, global armed conflict and its effect on climate change. Only one judge picked up that, and that was Justice Cleveland, surprisingly, the US judge. And it did really, it came about because I must say the submission of Palestine, the Council for Palestine. In fact, it was the Council for Palestine who actually brought that to my attention, or a group of us attention, she said, because Palestine argued that armed conflict um, so that is the production of weapons, bombs, ammunition, bullets. The mere fact that you drop hydrogen bombs has an effect on the composition of the atmosphere. Nuclear weapons, that's a whole different category. All these um, all these things have an impact on climate change. So armed conflict is really a climate change issue as well, without, of course, naming the conflict in Palestine, without naming the conflict in Ukraine, and also many other conflicts within the African continent. They said states are under obligation to pursue peaceful efforts and to stop these armed conflicts globally. So I think with that respect, I mean, think of it, who makes the weapons, how these weapons are made, how these weapons are manufactured. The amount of money we spend on manufacturing weapons is actually could be used to reverse the climate crisis, maybe 100 times over. So I think that was very instrumental coming from a United States judge. And a United States judge, even though we know these judges have security of tenure, 9 years, and perhaps could seek re-election for another 18 years. But I think it goes a very long way to know that that came from a United States judge. So I think that's just my summary. I could probably go on for a longer time, but I'm really open to any questions. And thank you very much, Noma, for the opportunity.
Thank you so much, Justin. I've been taking a look at our Q&A chat box, and it's still empty. So I would encourage the attendees that are listening to put their questions into that chat box specifically. Even though I can see a couple in the actual Zoom chat, I might miss one or two if they're not in that specific chat box. Thanks for those thought-provoking insights. I think you really touched on two very difficult but crucial dimensions of the opinion. So on one hand, you've got fossil fuel subsidies and licenses that could really actually amount to internationally wrongful acts, which is a huge game changer in terms of shaping our perspective and approach towards holding certain states accountable. It makes it much easier to do that when you've got this, the highest court in the land making a pronouncement on that issue. But then on the other hand, you've got then this existential challenge for small island states that you reference, who are facing sea level rise and difficulties with how we're likely to determine liability fairly across states in instances where land disappears underwater and sovereignty is challenged. I think that brings us very neatly to our next discussion, because while these questions are really global, they've got a particularly sharp focus and consequence for the continent, and that's Africa. Because Africa does contribute the least to emissions, we know that, and we also know that it faces some of the gravest climate threats. And to help us understand a little bit better about how the court's findings will help to basically shape climate justice here in Africa, I'm going to invite a speaker that's named after an African state. His name is Mr. Zimbabwe Chimga. I hope I pronounced that correctly, or you can call him Z. Z is an award-winning international human rights lawyer with expertise and experience in the areas of democracy, governance, international law, and human rights. He is currently the technical lead at the African Climate Platform, where he is spearheading the litigation initiatives before the African Court on Human and People's Rights for an advisory opinion on human rights obligations of states on the continent in the context of climate change. Today, he's going to discuss the direct implications of the ICJ judgment on the African AO process. Please welcome Z.
Thanks, Norma, and greetings to everyone on the call. And I'm quite honored to speak after great academics and activists within the climate justice space, Justin and Joey. So I'll just pick it up from there, given the times that we've been allocated, and continue on the topic that Norma has been kind to place before this honorable grouping that is online. So I've been working within the African Climate Platform space, which is a coalition of more than 100 organizations that are working within the climate justice and environmental human rights space. And I've been leading with the process of drafting the request for advisory opinion that was filed before the African Court on Human and People's Rights. And I think we must all agree that it's quite a great time for the globe, where we are seeing all these processes happening across the globe, the ICJ process, what we've seen in the American system, in the ITLOS process, as well as what we are doing here in Africa, just trying to understand what is this scope of rights, climate rights and environmental rights in the context of the climate crisis that we are having to deal with. So I'll speak briefly about the request for advisory opinion that we filed before the court, and then link that with the judgment that has been spoken about by previous speakers, and how that then how we can leverage the judgment before the ICJ. So as I have said, we have been working on this. We did quite a lot of research in the past year or two, I must say, around the climate crisis issues that we see on the continent and how these affect the human rights of citizens on the continent. And I'm glad to say that on the 2nd of May, we're able to file the request for an advisory opinion before the African Court on Human and People's Rights sitting in Arusha. The main applicants in that case are our brothers and sisters at Pan-African Lawyers Union and the African Climate Platform that I've spoken about, and Natural Justice and other human rights organizations in the continent that are supporting this case. And I think in the same mold as what we've had before, the issues that we've placed before the court, primarily the interpretation and application of human rights that and the obligations of states in the context of climate crisis. And we do ask the African Court to specifically delineate a number of obligations in the context of climate crisis. And I will not go through all of them because there are quite many, but I'll just highlight some of the key ones that we think the court should interpret. And these include the human rights obligations towards past, present, and future generations affected by climate change. We also invite the court to interpret the obligations of states to protect vulnerable populations, including environmental human rights defenders, indigenous communities, women, children, the elderly, and people with disabilities. We ask the court to interpret the applicable obligations concerning a just, transparent, equitable, and accountable transition. We also invite the court to interpret the applicable obligations in implementing adaptation, resilience, and mitigation measures in the context of the climate crisis. We have also asked the court to interpret the applicable obligations concerning compensation for loss, damage, and reparations. And I think it's quite important that I highlight the fact that we are anchoring this. A lot of people have been asking, how is this application different from the other applications for advisory opinions that have been brought in other global spaces and in the Inter-American system. And the nuance that we bring before the court is we are anchoring this application on the African Charter on Human and People's Rights, because that is the primary human rights instrument that bind African states insofar as the implementation of human rights is concerned. So all of these are obligations that I've highlighted. The list is not exhaustive. I've just highlighted the main ones. We anchor the arguments on the African Charter. Of course, there are other international human rights instruments, the custom, and other applicable human rights sources of law that will use to reinforce the argument when the time to argue the case comes. But the anchor of our arguments happens to be the African Charter on Human and People's Rights. I think that is important to highlight. We also invite the court to especially define the obligations on states concerning third parties that are also contributing to the climate crisis. And we also think it's very important for the court to interpret the rights of citizens in the context of the traditional emitters, the historically high emitting countries, including advocating for climate justice and the demand for climate finance, seeking compensation for loss and damage, and promoting equitable burden sharing in the context of climate crisis. So broadly speaking, these are some of the questions that we've placed before the court. And I think the most important thing that has happened whilst we filed this case is the ICJ judgment that has been spoken to adequately by the previous speakers. And to us sitting on the continent, we see this as a pivotal moment for Africa's own climate justice journey because of some of the pronouncements that have been made on ICJ, which we think are quite relevant to the arguments that we've placed before the African court, for the arguments that we'll be making if we are invited to make oral submissions or any subsequent legal arguments to enable the court to make a pronouncement. I will not spend much time articulating some of the findings of the ICJ because I think that has been summarized quite well by Justin, and Joey also spoke to that. But what I will do now is to also articulate a bit more what the relevance of the ICJ judgment has on the African processes that I've spoken about. I think the first important point to make is that a number of the questions that we have asked the court to define have in some way been answered by the ICJ. So the ICJ judgment then serves as a legal source of interpretation of some of the arguments that we are making. One of the points that we make is that although Africa is historically, and this is proven by the science out there, to be one of the least contributors of the climate crisis, it happens to be one of the greatest victims of the climate crisis. And it is quite important for us, for the African court, to define clearly what then that means, and how then can the African citizenry enjoy the rights in a context where they are not contributing to the emission that we see globally. The second point that is quite important that's come out of the ICJ is the rights-based approach that the ICJ has taken. As has been said by the previous speaker, the ICJ has recognized that the climate-induced harms represents a rights, um, a violation of rights. And as I have said, in our case, we make the point that the climate crisis is a human rights problem. And we anchor the human rights problem in the rights that are supposed to be enjoyed by the citizenry in the African Charter. So in our minds, we see the ICJ as contributing the rights-based arguments that we bring before the court. And we hope to use the ICJ judgment to strengthen the arguments that we've already made. And I think that is quite important. Then the second point that we see arising from the ICJ is the fact that there is complementary frameworks that are working in resonance. By making these robust human rights pronouncements, the ICJ has laid a legal foundation that we think the African court can build upon and adapt to the African context and highlight rights-based approaches that take into account continental nuances and the available and applicable human rights instruments that I have also mentioned. The third point that I wish to raise is that there is normative reinforcement in all this via the ICJ's authoritative interpretation of global climate obligations. And the ICJ strengthens the legal foundation for the African court's eventual opinion whenever it's handed down, particularly regarding the state responsibility to mitigate climate change, protect human rights, and provide reparations for climate harm. So we see an alignment in the arguments that we've placed before the court and what the ICJ has said. And I think that is a great thing. We are also humbled by the way the ICJ has sought to protect rights of vulnerable groups. As I have said, one of the key points that we place before the court is the special need to protect rights of vulnerable populations that include indigenous peoples, women, children, and climate refugees in the context of the climate crisis that we see globally. So we think that these pronouncements that have been made by the ICJ have got special relevance for Africa, where climate change exacerbates existing inequalities and vulnerabilities. We also think that the ICJ comes in at a very important time in clearly articulating and also enhancing state responsibility in the context of climate change. The opinion makes it clear that states, and this includes African states, have obligations to regulate not just their own actions, but those of private actors operating within their jurisdictions, including multinational corporations engaged in fossil fuel extraction. Joey and Norma have already spoken at length about the way the ICJ has dealt with the problem of fossil fuel extraction and other high emission activities, a problem we also see on the continent. The fact that the ICJ has pronounced on that and placed squarely responsibility on states just supports what we have argued in our request for an advisory opinion, and we believe that the court will come out strongly and align itself with the pronouncement of the ICJ, but also define those obligations in the context of nuances on the continent. We also think it's important that the ICJ's framework establishes that inaction or inadequate action on climate change, of course, they choose their language carefully. As Justin says, they use the words may constitute an internationally wrongful act, potentially creating new avenues for accountability through regional and domestic courts. And I think it's a good start, and I think the court, the African court, can go further and have stronger language than what we've seen before the ICJ, and we'll be arguing for that once oral submissions are made, and we'll see how that goes. But I think even that language is presently framed by the ICJ is useful for activists and advocates on the continent to push for human rights obligations. There are many other aspects that come out of it, but I'm mindful of the time that has been allocated. And I'll just jump to the conclusion and make the point that the ICJ has made important pronouncements on human rights. And what I see is the handing of the baton to regional systems like the African human rights mechanisms by the ICJ, where the African court will build on what the ICJ has said, but also contextualize and implement these groundbreaking legal principles at the continental or regional level, if I can put it that way. By embracing this responsibility courageously and strategically, we think that the African Court can not only advance climate justice on the continent, but also contribute to the progressive development of global climate jurisprudence that centers on the needs and rights of most vulnerable members of society in the context of a spiraling climate crisis. Let me stop there. Norma, I've just gone past the 15 minutes. Thank you.
Thank you so much, C. With a name like that, you cannot help but to be Pan-African in all your approaches to your work. And I think you've highlighted just what makes this specific African AO so different from the other advisory opinion processes that are going on in different jurisdictions, which is the fact that it has some sort of regional approach and regional context to it in relation to climate obligations. And thank you as well for highlighting to us some of the opportunities, but maybe some challenges as well for African states when it comes to operationalizing the ICJ court's findings. Building on that foundation, we're going to move on to our next speaker, who's Lucien Limoshe. He is going to take us into the realm of strategic litigation and is going to help us understand how lawyers and advocacy groups, as well as civil society, can translate some of these findings into actual concrete cases, holding states and state actors accountable when it comes to shaping climate policy across the continent. I'm just going to say a few statements about Lucien. Lucien is the head of programs at Natural Justice, where he leads multiple work streams and initiatives across the African continent. He works closely with teams across the organization to ensure strategic alignment, impact, and innovation in natural justice's programming. He also holds an LLB and LLM from the University of Witwatersrand and is a qualified attorney and mediator of natural justice. Lucien has been involved in over 30 strategic litigation cases, contributing key insights to legal strategy and implementation. Today, he's going to take us into his confidence in highlighting the influence of this court finding on strategic litigation cases on the continent. Welcome, Lucien. You have 15 minutes.
Thank you so much, Norma. And I think there's always a benefit going last, because a lot of the information I was going to say has been covered by our distinguished guest speakers. And must I say, it's been an honor to be part of this panel, really inspiring presentations from all three. So thank you for that. I suppose maybe just to start off with the ICJ advisory opinion for Africa, I think is historic, right? It affirms climate change as a human rights crisis, and it binds legal duties of states and obligations to regulate private actors. And I think really that is what's critical when we want to look at strategic litigation on the African continent, is how do we make sure that there is accountability to those who want to come and exploit or extract or impact the African continent in one way or the other. So I think from that perspective, it's really important. And of course, the other one is holding states accountable for the operations of corporations, whether international or locally. From the civil side, for African actors, this I really believe is a turning point. You know, it in so many ways, it strengthens the African advisory opinion petition and equips civil society, governments, and regional bodies with strong legal ammunition to really hold, those who violate rights accountable. And then maybe just a last little introductory point, there's a key golden thread here, right? The ICJ, the African advisory opinion petitions are not parallel tracks, right? They're not separate, they're not doing their own thing, but they are mutually reinforcing. So I think with the advisory opinion coming online, line, and having that judgment hopefully sometime next year, will just reinforce what the ICJ has said and just amplify our opportunities on the African continent to hold those who are going to potentially violate the climate and the impact that it has on the African continent. Now, Z very kindly mentioned that, we obviously have the African court, but something that's really important to also note is that Africa has 4 other regional courts as well. We've got the East African Court of Justice, we have the Community Court of Justice for ECOWAS, the COMESA Court, and then we had the SADC Tribunal that was unfortunately closed, and we have the African Commission as well. Now, the ICJ is obviously going to support further thinking and further jurisprudence development within these particular courts. Of course, these courts are more economic. They're derived by treaties signed by various states, but within those treaties, many references are made to international law, international customary law, and of course the African Charter, and then the rulings that come out of that from the African Court. So I really believe, from the African regional perspective, when we're looking at litigation, that this particular judgment is going to be amplified. My colleague Justin has mentioned, I think for these courts in this type of litigation, having the IPCC as the authoritative science is going to expound and develop further strategic litigation cases. We now have a body of scientific evidence that is going to be very difficult to be challenged in court. Not to say that it won't, most likely will, but it will certainly help and bring confidence to the judges who want to put rulings against those who violate, whatever rights we're talking about, whether it's socioeconomic, right to a healthy environment, etc., etc. In terms of ECOWAS, what's really interesting here is that there is obviously socioeconomic right cases that have been brought before it. The most famous one, the Serap case, and I think now we're probably going to see new cases coming to the ECOWAS court where they talk about customary duty to prevent significant harm, and then start tying that up to your socioeconomic right, typical issues that one would see. Another area that could potentially hold sway is, of course, transboundary pollution. So you've got water basins, air pollution, displacement, impacts to those areas of the environment will obviously launch impacts to your socioeconomic rights, your civil and political rights, and your environmental rights, and that then would provide some sort of foundation and basis to have a legal solution against those who are perpetrating it. In terms of nationally, which I think is quite an interesting area, because obviously international law is not particularly binding unless the constitution gives it veracity and there has been some sort of assimilation at Parliament, if it's a convention or a particular treaty. But if we have to take this into consideration, though, if you look at most of the constitutions on the African continent, there is reference to international law and international customary law. Being a South African attorney, I can safely speak to the South African Constitution, where we actually adopt international customary law as law on the South African continent, which means that the IPC advisory opinion holds a lot more sway in the national courts here, where we could potentially hold people accountable for whatever reason. Now, what's also really interesting in terms of this from nationally, as we know, there is a huge push around the common but differentiated principle, and what's going to be said now is that from a national perspective is that it does not give an excuse for inaction by government, and that all states must act. So if you look at the ICJ, I think it was at paragraphs 148 to 151, it essentially says, yes, we all have common but differentiated responsibilities, but there are still responsibilities that need to be impacted and need to be rolled out, and that all states must be held accountable and must act. So I think that's going to be a huge turning point in terms of how we can start aligning our strategic litigation, because it means we can hold governments accountable for violations with this particular ICJ ruling. The other one, which is really interesting, is around corporate accountability. So Z had touched on that a little bit in the beginning around corporate accountability when it comes to the advisory opinion. And on the African continent, and maybe this is another distinguishing fact, is that the African Charter clearly states that countries need to hold the private sector accountable and make sure that there is a process in a way where the resources, natural resources, are actually utilized to the best interest of that particular country, particularly when we're talking about foreign monopolies and corporations. So when the ICJ emphasized, states must regulate private actors, I think that's going to be a really big theme coming out from the advisory opinion. But more notably, from a national perspective, I think this gives credence for us to really push hard as civil society in looking at how do we hold corporates accountable in terms of how the ICJ had framed it. And that obviously would include oil, gas, mining, agriculture that has an impact on the climate and opens doors for suits, against governments if they don't hold corporations accountable. Another area that could be quite interesting is around climate displacement. So the ICJ acknowledged that there is a disproportionate impact on vulnerable groups. If you look, I think it was at paragraph 387, 384, civil society can potentially test and states' duties around and protect people who are going to be displaced because of the climate crisis. And then lastly, which I think is a real passion of mine, and those know is around food security. So Africa, obviously, we're looking at a perspective of we're the least polluting continent in the world, yet we're going to be the most impacted. And one of those impacts is going to be extreme famine and food insecurity, and the other one is going to be around massive floods and displacement. And so around the food insecurity and famine, obviously we can frame this as rights violations, which are tied to state submission. So if states in Africa are not going to start acting and making sure that they start developing adaptation programs that can secure food sources, that protect clear biodiversity areas, that provide resources to communities, that is certainly an angle that can be taken, particularly in light of how the ICJ had said it. And then, of course, there's a stock standard cases that we can look at that will be amplified, loss of biodiversity, loss of heritage and culture. So that's it's all really interesting. Again, I think the golden thread here is the ICJ's affirmation that state responsibilities and reparations are key and are here and need to be implemented, and that, of course, just really strengthens the advisory opinion and for the push for loss and damages. Lastly, the role of national human rights institutions. I think this really gives an opportunity for them to look at how they can monitor compliance with the ICJ findings. There is so much in there that can be extrapolated in monitoring and making sure government is following particular processes and systems and policies that support communities, that support poor and marginalized people, support vulnerable groups. I think this could be a key area for them to potentially look at. And similarly, the same with the African Commission. We can build on the resolution 372 and have stronger opinions of general comments and have thematic inquiries on climate justice. And then from a Pan-African Parliament perspective and the African Development Bank, as a last point, I think here, really, with civil society, we need to start linking accountability and just transition finance and implementation of reparations. I think, with the COP that's coming up right now, we know that Africa has a huge push, and it's the theme for this year around reparations. And how do we make sure that we transfer those principles, those ideas, and make sure that we hold the global north accountable? This is particularly an area that we can really push. And in light of what the ICJ had said in terms of reparations and damages for historical emissions, I mean, this is certainly an opportunity for the African governments to go there with one voice and say it's time for change. So yeah, I'll stop there because I know we are running out of time, Norma, and I know there's some people who have some questions. Thank you.
Thank you so much, Lucien. I think we're making such good time today, so I'm really happy with all the panelists for being super considerate and keeping to time. Really, really positive sentiments, I think, coming from your side about this specific finding from the ICJ. And we've highlighted that the findings are really going to give judges, at least in Africa, confidence when it comes to strategic litigation cases, and how we're likely to see a lot more new cases broadly, whether in regional courts like the ECOWAS courts or national cases where already a number of different jurisdictions in Africa are empowered to reference international as well as foreign law in instances where that's appropriate to do that. You've also highlighted that this process is likely to continue to support the specific legal analysis tool whenever some of these cases make it into domestic courts. I'd really like to thank all of our speakers for their thoughtful invitations. And now I'm going to open the floor for questions and comments from our participants. I did see a question from the chat box. I'm going to invite the person who tabled the question to ask that question if they'd like to do that. If not, I'm happy to read the question on their behalf. I don't see a hand. Nadia, are you still online? I will read the question. So this question is tabled to any of our panelists. It says, how can civil society best mobilize in the next few weeks and months to bring the ICJ and other opinions into policy spaces to strengthen action and implementation? She cites examples like New York, as well as Africa Climate Weeks, COP30, and subsidiary events linked to Rio Convention. So this is more about the advocacy aspect of this process and trying to use the momentum coming out of the findings made by the court to galvanize different sectors of civil society. Happy for anyone on the panel to answer this question. Maybe let me start with Joy first, since you spoke much broadly to the importance of civil society organizations in AO processes. Would you like to take a stab at it, Joy?
Sure. Thanks, Noma. I'm just reading the question one more time. Yes, absolutely. So civil society is mobilizing, and we're very happy to connect, Nadia, if that would be helpful, through one of the different coalition spaces where these conversations are happening. As you rightly point out, New York Climate Week is a great opportunity. One of the pieces that happens after an advisory opinion is delivered is that there is a UNGA, a UN General Assembly resolution that is passed and that can have some elements to operationalize, like Noma said, some of the pieces of the opinion, while powerful, were not very concrete because of the nature of an advisory opinion, right? Which is clarifying international law, but it is not a fact-specific context. So the court has, left it to future contentious proceedings or future discussions to really kind of go into the more granular detail. But the UNGA resolution is a great opportunity to both welcome and socialize the key progressive elements of the opinion with states in the UN General Assembly, but also to bring in operational elements that kind of bring in a bit more of that granular detail. So New York Climate Week will be the time when it will be announced by Vanuatu and other leading states, and then taken forward both at the diplomatic level, and there will be ways in which civil society can support. And there are a lot of specific implementation related events that are happening at New York Climate Week. So please do connect with us if you are interested in that. There are 4 areas where there's a lot of momentum happening right now in terms of implementation. One, as Lucian mentioned, this obviously is very critical in terms of operationalization, in terms of getting this more granular to make this mean something in our contexts and jurisdictions, to bring this into domestic cases. And a lot of lawyers from all over the world are thinking about this, are bringing it into court. No, Natural Justice introduced it, right? And you're in the Peel and the Shell case. But we have lawyers from India and from all over Latin America and from the Swana region that are like really thinking about, okay, what does this mean in terms of us bringing it into the courtroom? So those discussions are happening because this litigation is happening in like super kind of confidential mode, but it is definitely happening at the international, regional, and national levels. Another huge area is what is going to happen at COP30, because COPs have really kind of broken down in terms of like the political stalling that we're seeing on absolutely critical issues for our very survival. And what the court has come in and said, like, no, you know what? Not only does this entire spectrum of relevant international law apply, but one of the big arguments by big polluters was that, you know, Paris and UNFCCC, mostly Paris applies to us and nothing else. And Paris doesn't really obligate us to do much. And what the court came in and was like, no, you know what? That's wrong. Lex specialis of Paris is not a thing. A wide spectrum of international law applies. And Paris and UNFCCC have binding obligations and are really critical. So that is important. That changes the landscape. What are we going to do about it as civil society? So that planning is going on in full force. Very happy to connect, Nadia, with you, with different organizations all over the world that are thinking and coordinating around this. And then the last thing is that it really gives us power in different campaigns. We have campaigns all over the world on reparations, on the right to a healthy environment. Sea level rise is causing so much distress to our communities. So campaigners are really critically thinking about, okay, how can we take some of this legal foundational findings of the court and really use it as a way to kind of supercharge some of the campaign demands and push governments. So we saw like South Korean groups, for example, pushing their governments to do more in terms of national plans based on the strong language of the court on nationally determined contributions. So a lot is happening. Civil society is, you know, really mobilizing around this, and we love to include new people into like, you know, maybe you're already very involved, but NOMA's connected to all these different coalition spaces, as is Lucian, and you know, it's always amazing to think through and brainstorm together how we can make this opinion really come alive.
Thank you, Joy. I love that you touched on the opportunity for the AO to give legal clarity when it comes to legal interpretation. So how we interpret different obligations may be very different, but this sort of gives people a yardstick and a guideline. And I think it also speaks to Ahmed Asaidi's comment in the chat. I think I tabled a question about, you know, how can we use this finding in our day-to-day understanding of our own jurisprudence within our different jurisdictional contexts. He says, I think this is a good opportunity for domestic judges to understand the climate justice plus the relationship between climate change and human rights. So they can use this AO directly in their judgments. And I think that speaks to your point and also to Lucian's point as well, about how we can make this a live document and more practical in our different jurisdictions and contexts. And the advocacy continues, right? It doesn't stop when you get the finding. In all these other different platforms and spaces, we can still continue to unpack the meaning of different salient sections of that finding. I'm going to move now to Justin. There's a question here, Justin, for you, and any other panelist is also welcome to answer this question. It says, which aspects of the ruling do you think are most progressive outside of the ratio of what constitutes a wrongful act? And where does ambiguity remain? Justin, would you like to attempt to answer that one?
Sure. Yeah, well, there are many important aspects. Fossil fuels, of course, was one of the main ones. But if I could just pick maybe two, which I think are very important. One of them is the articles on state responsibility. The fact that the ICJ actually said we have dealt with it before, so why can't we deal with it again here? We have accepted its weight, especially coming from the International Law Commission. So why can't we deal with it now? And I know some states were actually blocking that, especially as a mode of the part B of the question in terms of consequences. So the ICJ really went into the articles on state responsibility. They looked at cessation, compensation, satisfaction, and reparation. So I think also Lucian spoke about that as well. So it just reconfirmed that the articles of state responsibility is or can be used in terms of directing consequences with respect to climate change. But the for me, outside of that, a very contentious issue which the ICJ cleared up was whether greenhouse gases could apply to the no harm rule, or whether greenhouse gases could apply to the duty to prevent significant harm to the environment. And some states, especially the global north states, said, well, the no harm rule only applied to transboundary matters. So, we saw it in the pulp mills case, it only applied to if there's pollution in a river between Argentina and Uruguay. And if we use greenhouse gases, how do you know? It's so diffuse. There's so many sources of greenhouse gases. How can we say that the greenhouse emissions coming from the United Kingdom, for example, would cause sea level rise in the Seychelles? How can we do that causation link? So they were trying to say that greenhouse gases do not apply because of the broad context, do not apply to the customary international law of the no harm rule. But the ICJ, of course, well, that was something that was on the fence because the ICJ never dealt with whether greenhouse gases apply to the no harm rule. So I think for them to come out now for the very first time to say that greenhouse gases affects the climate change globally, even though it's diffuse or from multiple sources, that states are under obligation to not produce greenhouse gases because it's contrary to the customary international law rule of the duty to prevent harm to the environment. So I think for me, those were the two cases. Of course, sea level rise was important. We discussed that. My only problem is how we actually apply the ICJ ruling to sea level rise, because I could see it may be a bit problematic, but I think we can find some ways to get around it. So those are the main ones I think I would like to mention. There are many great movements that they made, but I think those were the ones I would like to mention for now. Thank you.
Thank you, Justin. I think the point that you touched on, which is an area of, if you're in this side of the world, you'd call it delict. If you're maybe, I don't know, in America, you'd call it tort law, but causation, that is a huge element when it comes to establishing any sort of liability. And I think the fact that the court talks to the challenges involved in being able to find that causal link, but also the fact that whilst there is a challenge, this does not negate the obligation to be able to rely on scientists, persons with particular expertise that are able to help with the assessment of that causal link, as well as to help with the quantification of how do you measure damage that has happened over decades, sometimes hundreds of years, and caused by multiplicity of actors. So not just one actor, but joint actors and joint liability. And the nuances of that was something that was also discussed. I found that framing, yes, whilst it wasn't clear, I did find it framed at least very positively, in the sense that there is room to be able to still advance that legal reasoning. I'm going to now move on to Dee. Dee, there's a question here for you about centering the advisory opinion process in Africa, specifically on the African Charter on Human and People's Rights, and how this approach basically differs compared to the ICJ advisory opinion process. Do you mind speaking to that issue?
Yes, surely. Thanks, Norma. And I think I touched on that briefly in my first presentation, that the nuance that we bring with this process is centering it on the African Charter on Human and People's Rights, right? And that's quite deliberate from a legal point of view. Almost all African nations are part to the African Charter on Human and People's Rights, except one. So it is quite important for us to end our argument on something that the states themselves acknowledge as being party to. And I think that is important. Then secondly, it's also important because the charter itself has got some important and I think more progressive provisions, not just around the right to health, around to environment, but the developmental provisions that are in there that you do not find in any other international instruments. So we think from an advocacy point of view, from an implementation point of view, and from just a Pan-African lens, it's very important to anchor our arguments on the African Charter. But I think, Norma, it's important to reiterate that it's not done in isolation. There are also important principles that emerge from the ICJ judgment and also from the Indo-American system. So we see, firstly, this as a primary argument, but we also see the complementarity coming from the ICJ and other international instruments. So it's all of these things come together to strengthen the enjoyment of rights on the continent.
Thank you so much, T, for that clarification. Lastly, Lucian, as briefly as you can, I think AOs globally receive a lot of flack for not being enforceable. So states are sovereign, and they can choose whether or not to implement certain parts of it, findings that are made by specific courts or not to. It's not a forced matter. How do you think this specific advisory opinion process is likely to, and I think you touched on this a little bit, some of the promising avenues for strategic litigation in Africa, but maybe since we had such limited time, any other avenues that you'd like to sort of highlight, given the context of this idea that advisory opinion processes are not useful because they cannot, a state can choose whether or not to implement it?
Yeah, I mean, I think with this one particularly, what really sets it apart is that it didn't say country A or B is accountable. What it has said is that we are open to hearing litigation cases for past historical emissions. And I think that's clearly a warning from the court saying that you can bring justiciable cases with damages or loss in damages, however you'd like to define and look at it, against countries that have been polluting for the last 50 to 60 years. And I think just looking at that particular point, it's clear that that there is more to this ICJ opinion than just being an advisory opinion. And then secondly, it has also clarified so many issues that were in the lurch and has essentially um, legalified, if that's a word, the opportunity to hold corporations and countries accountable even at a national level, because now there is finality and certainty on some of these key international principles. So I think from that perspective, that is why this ICJ opinion is so important. And of course, the inspirations part of it is on the other side, right? Civil society, as Joey said, Joe said, we can take this on. You know, there is accountability. The courts, almost every regional court in the world has said that we have to do something. I mean, that has volume. That speaks to the fact that we need to act now. So yeah, I think there is huge advantages of advisory opinions, and particularly this ICJ one really took it a step further for civil society and people who need to litigate against those who violate. Thanks.
Thank you so much, Lucian. Very well said. It is the top of the hour, so unfortunately, this brings our webinar to. It's not the top of the hour, actually. It's just the time that we have, unfortunately, has elapsed. And so, as we wrap up, I'd really like to extend my deep gratitude to all four of our speakers, as well as our interpreters who are joining us today, our technical team from Stractivate, and the attendees that have been engaging with us today and have made this discussion a lot more enriching and insightful. Today's conversation really showed us that whilst the ICJ advisory opinion process is a progressive milestone, it's also a contested one. And for Africa, it presents both opportunities to push forward climate justice agendas and challenges, particularly in negotiating accountability and responsibility in a global system that has often marginalized the continent's voices. This is not the end of the conversation, but hopefully the beginning of deeper work, as Lucian mentioned, across different spaces, whether legal, or advocacy, as Joy highlighted, in different community spaces. So thank you once again for joining us. And please remember that the recording, along with the French transcripts, are going to be shared with participants after the session. So please do look out for that on our social media platforms, as well as Natural Justice's website under archive. Thank you, everyone.